Hi friends, welcome to the fifth class of Law of Torts, and this is Lokesh Pathak with you. And today we are going to discuss a very important topic, which is general defenses in tort. These defenses are certain times referred as favor defendant. Favor defendant means the burden of proof for proving these defenses lies on the defendant, and that is why these are called favor defendant. But in that case, when he is required to prove, what he is supposed to do is only he has to prove that the occurrence of event for which he want to take a resort, if he just prove that that occurrence of event it happened, he will take the exemption. So be mindful that it is also called favor defendant. Now today we are going to refer 8 exemptions, or basically 8 defenses which are being used or which can be used in law of torts to avoid the compensation or the responsibility or the liabilities. What are those? The first is based on the maxim, which is volenti non fit injuria. It is based on the maxim of consent. It is a Latin maxim, and which means it is a maxim of consent. So here it says, if you provide your consent to bear any loss or injury, you lose the right to claim for it. Means if you give your consent, being a major, if you give your consent, you cannot pass on the responsibility of the injury which has happened to you to somebody else. This is generally being considered when the consent forms from various doctors or sports persons are getting signed. In general, you might have seen those consent forms. So this says that if any injury or any loss happens to you because of the event which you are going to do, the other party will not be liable, and it will be you who will be liable because you are giving your maxim of consent. Now, what is the principle behind this maxim of consent, which is volenti non fit injuria? It has 2 elements. First is the plaintiff, he has a knowledge of the risk. If you go through the form, all the risk has to be mentioned there, and it is a confirmation or undertaking from you that you have gone through all the possible risk and their occurrences, their chances, and that is why you have now the knowledge of risk. On the other point, the consent, which is important, and that consent should be free consent. It should be free from coercion, undue influence, fraud, misrepresentation, or any mistake, as we can relate with Contract Act section 14 to 22. The same thing is applicable here. So the consent should be free, and the person should have the knowledge of the risk. If these 2 elements are satisfied, then the volenti non fit injuria applies, and if a person is giving his consent, he loses the right to claim for the compensation for it. Now the case supporting it is Hall versus Brooklands Auto Racing Club of 1932 from English jurisdiction. The facts of the case are that the plaintiff, he went to see the car race and he took the front seat in the auditorium. Now due to some collision between the cars, he got injured, and then he made the claim on the stadium, on the racing club. So it was held that since you gave your consent, you are aware about the risk, you had the knowledge of the hazards, so you lose your right for the compensation, and hence he was given nothing. Now, alternative to this maxim, there is another maxim which supports the plaintiff if he has not given his consent, and that maxim is scienti non fit injuria. I am repeating, scienti non fit injuria. It is alternate maxim to volenti non fit injuria. Scienti non fit injuria says that mere knowledge does not provide consent. It means if the person has the knowledge of the risk but he has not given his consent, he will not be liable for the injury caused to him. So the case which governs this is Smith versus Baker case of 1891. I will take you to the facts of that case now. In that case, what happened? The plaintiff is a workman who was employed for rock cutting by a defendant. Now there was a stone who fell on his leg and he got injured while there was a crane movement in his factory. Now it was held that the owner is liable because although the plaintiff was having the knowledge, but he has not given his consent for the risk because he was not a regular employee over there, and also the crane movement, the owner, he has not used the warning signs for the crane movement. So he made a violation from his side with regard to safety points, and also the person who just came there for cutting the rock, he was not a regular employee. So he was having the knowledge of the risk, but no consent was taken for him. So that is why in Smith versus Baker case, the scienti non-fit injuria applies, and it was held that having knowledge does not mean the consent, and that's why the plaintiff was given the compensation. Now, other cases on voluntary non-fit injuria and the type of consent that needs to be seen, because this is a very important topic and very important defense, which is related to the law of torts. So we'll see some of the couple of the other cases also that will help us to understand the topic. Another case on voluntary non-fit injuria is Padmavati versus Duganaika. The facts of that case are: there was a person in jeep, he was going for a patrolling, and two strangers, they took lift. Now, stranger, while they took the lift and the jeep was moving, they thought that the jeep is not fit and it may be subject to rupture or it may collapse. An accident may happen. So, anticipating that, they jumped. Now, one of them died and one got injured. So they brought it to the litigation. Their successors, they took it to the litigation. Now what happened? What was the finding of the court? Court held that the jeep owner is not liable because voluntary non-fit injuria applies. They were aware about the risk when they set it. They were aware about. They gave their consent while they set it over there. So why the jeep owner is liable? No, he's not. Another case is Thomas versus Quartman, 1887 case from English jurisdiction. Now, the facts of that case is the plaintiff was working in a wine factory, brewery basically. There was a hot water in big pots, and he was trying to remove one lid from a pot by force. And he got slipped, and the drum, he got hit with the drum on the backside and got injured. Now, he filed the case on the owner, and he said that I got injured because of no fault of mine, while it was because of the owner, because the big pots, hot water, they were staying nearby. So court held that since you were working as an employee, you had the knowledge, and being an employee, you gave a free consent. It was free from coercion. So in that case, voluntary non-fit injuria applies, and you are responsible. So it was held that the plaintiff himself was responsible, and hence no compensation could have been given to him. Now the consent, as I said, it should be free. It should not be forced, or it should not be based on fraud. To support that, we can see one case, which is R versus Williams of 1923. The fact of that case was there was a consent obtained by fraud, which, because accused was a music teacher, and what he did, he had a sexual intercourse with a minor girl to whom he was teaching. And he said that if you had sex with me, your voice will improve. So this was a fraud, and also the case was involving a minor. So here it was said, since the consent was based on a fraud, hence voluntary non-fit injuria cannot be applied. At the forced consent was, as the free consent was not given. So the accused was held liable. Now there is another case which is basically based on the intensity of the reaction of the defendant. That is Elot versus Wykes case of 1820. In that case, the facts are that the trespassers were shot by a spring gun on a land, and which were mounted by the owner of the land. Now it was held that trespassers, they themselves are liable because they were entering without the consent. But what criticized in this case was the use of excess force by the owner. Now these are all the cases related to voluntary non-fit injuria, but there are some exception of this maxim also. It doesn't mean that if you take a free consent, you can do everything. No. What are the exceptions in this maxim? The first exception is the unlawful action, which says that no consent can legalize an unlawful action. Also, second exception is the breach of statutory duty, which says no consent of this maxim is applicable or valid for a breach of statutory duty. You cannot just take a consent and allow somebody to violate a statutory law obligation. The third exception for this maxim is negligence. For that, we can understand with the help of a case, which is Dan versus Hamilton. It is a 1939 case. The facts of the case are that a plaintiff, he got a car and the driver was drunk. So, but she still onboarded on that, knowing that the driver is drunk, and the car suffers an accident and driver dies. Now, and she had an injury. Now, when the successors of the driver they faced the case from the plaintiff, then they said they raised the point that the lady, the one who was on board, she was aware that the person is drunk, and since he said it, it gave her consent also. So it's applicable that because she consented, no compensation should be admissible. But court did not decide it so. He stated that the case is negligence. Even she gave her consent, but the driver was negligent in his duties. Hence, voluntary non-fit injuria will not be applicable in such case because it is involving the negligence, and hence the lady got compensation from the successors of the driver. So these are the three exceptions to this maxim. So this was the first exception or defense we discussed, which is a big topic, which is voluntary non-fit injuria. We seen its conditions and elements. Then we have seen the case law supporting this and the opposite maxim of this also, which is scienti non-fit injuria. Now the next exception or defense is the plaintiff, the wrongdoer. Means if the plaintiff, the person who is bringing the litigation, if he is the wrongdoer himself, then the defendant is released from his obligation or the possibilities of compensation. Now, but the court decided that this point only is not sufficient to reject any claim. There was a case supporting this, which is Bird versus Holbrook, which is 1823 case. Now, in that case, plaintiff was a wrongdoer because he was a trespasser. He entered into some other person's property, and there were pistols like spring guns were there, and he got shooted by them. Now it was cited by the defendant that the plaintiff himself is a wrongdoer. He entered in the property without consent. But in that case, the court decided that the plaintiff, although he is a wrongdoer, but you cannot exceed the force. You cannot penalize somebody for entering with a shoot of a pistol. So that is why in that, although the plaintiff, the wrongdoer, was cited, but the decision was in favor of the plaintiff only. He got the compensation. Now the third exception or defense is the act of God, which is very important. It is also called visa major, means based on the natural forces. Now in that, there were three jurists who has given their interpretation of this act of God. One is Winfield, another is Salmon, and third is Pollock. We'll see them one by one. What Professor Winfield has said, that act of God is an operation of natural forces. It's so unexpected that no person or human of foresight or skill could reasonably be expect to anticipate it. So Winfield, what he did, he related the act of God with a reasonable anticipation, that nobody with a normal pursuit can reasonably anticipate this. While Professor Salmon, he related that with the reasonable prevention. He said that an act of God may be defined as any event which would not have been prevented by reasonable care or the art or on the part of anyone. Means he talks about the reasonable prevention is not possible with the natural forces or act of God. Pollock says simply that it is an operation of natural forces so unexpected to anticipate it. So these are the three interpretations which you should refer in your answers when you discuss about act of God. Based on all these interpretations and the details, we can see that there are two prime elements of the act of God. These are the first, working of natural forces. There must be the working of natural forces which are not in the control and limits of any of the natural persons. Second is the extraordinary occurrence. Just positioning of natural forces is not enough. They must be of some extraordinary nature, like a flood, like excessive rain, like earthquake, tsunami, something which is act of God, which is not the act of a human, which nobody can foresee, nobody can reasonably anticipate, nobody can reasonably prevent, and it is of an extraordinary nature. It's huge. So the case in support of act of God is Nicholas versus Marsland. In that case, the facts are there was an artificial lake which was made and heavy rain occurred. Now due to the heavy rainfall, the water from the lake came outside, and it destructed the property of the plaintiff. Now plaintiff, when he took the case to the court of law, it was cited that it was an act of God, because although the lake was artificial, but the rain was unanticipated. It was natural forces of extraordinary nature, and hence there was no compensation to the plaintiff. Now the fourth point here is necessity. How it is interpreted? It says, then an act causing damage, if it is done in necessity to prevent a greater evil or a greater act or a greater occurrence if which is not actionable even though it was done intentionally. Means to prevent a big evil, if you do something small although with the intention, that will not be considered as an offense or a crime or a act in the tort, because it is done with the intention and it is necessary, it is under a necessity to do something to avoid something bigger to the people. Now the fifth exception is statutory authority, which says that no compensation when the act is done in the pursuance of the legal works. The sixth defense is inevitable accident. What is inevitable accident? Sir Frederick Pollock, he defined it as an accident not avoidable by any precautions, as a reasonable man doing such an act then and there could be expected to take. Means some accident which is not possible for a reasonable person to anticipate and avoid. That comes under inevitable accident. Now let's see the case laws for inevitable accident. The first is Stanley versus Powell. Now the facts of this case are, there were two friends, they have gone for a hunting and they were walking with a distance. Now one of them, he shot a bullet and that bullet hit some tree and came back, got diverted, and it hit the another friend. Now the another friend, he brings the litigation. Now what happens? There's no compensation because it was a category of inevitable accident. There was no intention, there was no possibility that it can happen. It is a very rare occurrence that some bullet goes to a tree and comes back and hit the other person. So it is inevitable accident. So in that case, there was no compensation given to the plaintiff. Another case for this is Holmes versus Mathur. The facts of that case is that the defendant here, there was a servant and there was a dog who barked, and because of the barking of the dog, a horse nearby, he got agitated and he hit the plaintiff. In this case also, this is something abnormal. This is really an inevitable accident that generally it does not happen and nobody can anticipate that this will happen. So here also no compensation was granted. Now the seventh exception or defense is the private defense. We have recently seen that in the IPC, but here in tort, how it applies, let's discuss about it. We'll see a case first that will determine the importance of private defense in tort. The case is Cockcroft versus Smith. It is 1706 case from English jurisdiction. In that case, it was held that force which is not justified, means in private defense, the force is not justified when if you just merely, it is based on the thought of anticipation of attack. Means if the person he's seeking a defense in private defense, it should not be just based on the anticipation of the attack. Means you anticipate that somebody will attack you and you try to attack that person. It's not a private defense. There must be something genuine or reasonable. Based on that, you are allowed to do a personal defense. Also, it is said in the same case that the force will not be justified if it is by the way of retaliation once the attack is already over. What does it mean? That somebody tried to attack you, you gone from there, you waited for some time, and then you made your mind, and then you have gone for the attack. It is a retaliation. You think about it properly, and then you gone for a retaliation, citing that you will get a defense in the private defense. So that is wrong. So retaliation is not admissible. Attack based on the anticipated attack is not admissible. These two facts were discovered in this case. Now there is another case which is Bird versus Holbrook. It is 1823 ER case. In that, because we just discussed this case in the same lecture, I am repeating the facts of it, that there was a spring guns installed in the land, and when the plaintiff he entered there, the spring guns fired and he got injured. So here also it was held that the plaintiff is not responsible because there was genuinely no notice was displayed, and the force exceeded the as compared to the required. For entering a person in a land, open land, you cannot just hit a person with the bullet. So that is why in that there was an exception based on the private defense, but it was said it was not admissible here because the person in private defense, he has exceeded the force. The last point is a mistake. Mistake we have seen in the previous lectures also. Here I would like to name a maxim. which is ignorantia facti excusat, ignorantia legis nemnem excusat. I repeat, ignorantia facti excusat, ignorantia legis nemnem excusat. It means ignorance of fact is excusable while the ignorance of law is not. Means if you forget, if you are under a genuine impression that something is correct and you are doing the things with a good intent and for a benefit of somebody with no evil intent, then that will not be considered as a flaw on your side. But it does not cover ignorance of law. You must be aware about the law. If there any law is there, you should be aware, and if there is a law, then what that law is. It is deemed to be understood from you. The case law related to mistake is Gaya Prasad versus Bhagat Singh, which is 1910 AC. And that it was held that if the prosecution of an innocent person is by mistake, it is not actionable. So the importance of mistake has been seen with respect to this maxim as the case. So these are the 8 general defenses or exceptions in tort. You might have seen that some of them resembles with regard to the application with the one which we studied in the Indian Penal Code. But the effective implementation of those defenses is a bit different in tort, apart from the criminology. So this is all for this lecture, and in the next lecture we'll see about the next topic, which is strict and absolute liability. Thank you. See you in the next class. Bye.